Well, welcome everyone. Thank you for joining us this afternoon for this panel on and actually in celebration of Constitution Day, which is tomorrow. So as we're celebrating Constitution Day, we're going to be discussing whether the U.S. Constitution, in fact, protects the right to privacy. So I'm Sujata Gadkar Wilcox. I'm a faculty member at Quinnipiac University. I teach constitutional law. I think some of my students may be on this, so we'll be having further discussions on the Constitution in class. And so I'm just going to give a brief introduction, just for those of you, I know there are students joining us from Housatonic Community College as well. For those of you who may not be familiar with the Constitution, just a little bit of the framework and then a little bit on the right to privacy. And then I'll turn it over to Dr. Immacula Cann, and then she's going to speak about a specific area. Under that, we're thinking about the right of privacy, specifically when it comes to abortion and contraception. And then we're going to turn it over to Jean Rabinow to talk about other rights that are implicated more broadly in the right to privacy. So so let we get started. And Laurel, if you can pull up the PowerPoint. Terrific. So does the United States Constitution protect the right to privacy? And then you might have to click a couple of times to get to the next slide.
Oh.
Yep.
Too many?
Too many. Yeah.
One more?
Yeah, one more back. One in between that. Yeah, there you go. Perfect. Okay. So just as by way of background, what is the United States? It's a constitutional republic and a representative democracy. So a democratic constitutional republic. And that's important here because the Constitution outlines, so first we have what it means to have a republic is to have certain institutions like a legislature and executive courts that are there to help, implement the functions and roles of government, and also to help, in fact, make democracy more productive and perhaps limited in some ways. So we have a constitution, for example, that creates rights that are protected no matter what 51% of the population say. These rights are fundamental and they cannot be deprived from any individual, and that comes in the Constitution. The way the legal system is set up, so even having a legislature and executive and the courts, for example, we call that separation of powers. That itself prevents too much power from getting into the hands of one institution or one person. And that allows democracy to really flourish because it makes sure that there's a balance of power, that people will have access. We have limits, for example, or fixed terms for elections, right? That's part of the framework of a republic that allows, in fact, democracy to flourish. And when we say democracy, we mean people actually having a direct say in the government. So we have institutions that protect, right, that kind of public voice. But we also have some way for people to have consent and have their voice heard in government. And it's through representatives, not necessarily directly voting on laws themselves, but voting on representatives that then vote on laws. So that together we have this, both a republic and a democracy. So that's the Republican and the Democratic part. And then, of course, the Constitution, which creates kind of a foundational principles or higher order principles that govern that all. And particularly what we're going to be looking at is this concept of fundamental rights that comes in the Bill of Rights, which are the first 10 amendments to the Constitution. I just want to make sure that we take a step back and think about the way our government or our legal system is structured, and to remember that we have both a federal government and a state government, and state governments. So we have not just, and Laurel, you can go on to the next slide. So important to keep in mind when we say constitutional law, we don't have only one constitution. We have one federal constitution, and that's the US Constitution. And then every state has its own constitution. So we have many constitutions, in fact, and states are governed largely by their own constitutions and their own laws. The federal constitution, however, and the Bill of Rights has been applied to the states. Otherwise, it's generally a federal document separate from, state laws and the state constitution. But the Bill of Rights in the U.S. Constitution has been applied to the states through the 14th Amendment. And the 14th Amendment is an amendment that directly talks about the role of states. And so over time, it wasn't, by the way, always the case that all of the Bill of Rights applied to the states. So states, for example, were not necessarily protecting the right, the protections around search and seizure or due process that were required under the federal constitution. And over time, the court said, well, actually, the federal constitution, because of the 14th Amendment, requires states to do that as well. And this process happened gradually. So basically now all of the rights that we see in the First Amendment effectively have been applied to the states. But I think it's just important that you keep in mind that they're separate documents. But this process through which the rights have been applied to the states, that process is called selective incorporation. And so the court said, well, the first thing that's the most fundamental for states to do as well, and because there's a limit on the federal government, is to make sure that First Amendment rights are protected, the right of speech, the right to press, the right of religion, that states protect that as well as the federal government. Then they said also procedural rights, like particularly criminal procedural rights that are in the 4th, 5th, 6th, 8th Amendments. So due process rights, search and seizure rights, double jeopardy, all of those things need to be protected by states because, again, it's protected under the federal constitution, and that has to apply to the states as well. And the most recent application was the Second Amendment. So the court said the Second Amendment also applies to the states in the same way that it does to the federal government. Okay, but what are we talking about? We're not talking about those rights that are enumerated in the Constitution. There's also a separate jurisprudence or an area of law called the right to privacy, and that right was not necessarily explicitly enumerated in the Constitution, though it is part of several of the amendments in the Constitution itself. And so the court creates a right to privacy, and I'll talk about that. So Lori, you can go to the next slide. And when we say fundamental rights, a question is, what are fundamental rights? So these are the rights in the US Constitution, at least, that we take explicitly from the first 10 amendments, so the Bill of Rights, the 14th Amendment. But what's important for us now, and this is the conversation today, and particularly the recent Supreme Court decision that now puts this in question, is the protection of a fundamental right that's not enumerated, meaning it's not explicitly listed as a separate right itself, but has been recognized to be a fundamental right in the Constitution, and that's the right to privacy. Okay, so the right to privacy is a separate right that the court has recognized as a fundamental right, though it's not explicitly listed in the Constitution, it's inferred from amendments. Okay, great. And that's what we're going to look at today. So we'll think a little bit about, where do we get this right to privacy? The court has carved it out in different areas. We're primarily, I think, in the public narrative. You're thinking about in the context of the right to the body, in the context of abortion and the Dobbs decision, which overturned Roe versus Wade. The reason that's a privacy decision is because it's about the right to privacy in the body. And before that, we had a case that focused on the right to privacy in contraceptives. So contraceptions and all of the rights implicated, under this right to privacy, it goes well beyond just abortion or the right to the body. There are other cases, for example, Lawrence versus Texas, you have anti-sodomy statutes that were overturned because it's violating the right to private sexual affairs, private marital affairs, the right to decide how the schooling for children, right? So the court has looked at a number of different areas and said there is a right to privacy in these various areas, and over time has protected that right to privacy. And so altogether, these cases that you see listed here are part of the jurisprudence on the right to privacy. And some of those will be discussed by the other panelists. Okay, Laura. So what is the right to privacy? It is by the court and again, there's some question as to what is the status of the right to privacy now. It was understood to be a fundamental personal right, even though it was not explicitly enumerated. It's in several amendments of the Constitution, in particular, the Third Amendment. Okay, we don't really think about the Third Amendment anymore because we don't talk about quartering soldiers, but the Third Amendment was particularly important because there's a right to privacy in the home, and the government cannot force people to quarter soldiers in their own home because it violates the right to privacy there, which is what the Third Amendment is protecting. So the court looks at the Third Amendment to say there's a right to privacy in the home. The Fourth Amendment, when it's search and seizure, right, that you have some privacy in your body, in your things, and the government cannot just come and seize things or search things without a warrant, without probable cause, right? There's some balance. There's always, they have to show some cause before they're able to do that, because you have some expectation of privacy. And the higher the expectation of privacy, the more the government has to do to show that they can infringe on that. So they look at the Fourth Amendment, they look at the Fifth Amendment when it comes to due process protections. And then they look at the Ninth Amendment, because when one of the reasons the Bill of Rights was not incorporated or not part of the Constitution to begin with is because there was a debate as to whether or not, when you create a list of rights and you leave something off of that list, that may nevertheless be considered fundamental 100 years later, that it's going to be very hard for anyone to construe that as a right. And so what the framers did is they included the Ninth Amendment, which is basically a catch-all amendment. And it says that any rights that are not enumerated in the Constitution may nevertheless be fundamental and are still reserved to the people. And so looking at all of these amendments and all of those different areas in which privacy has become fundamental, like the right in the body, the right in marital affairs, the right to raise your children or to decide their schooling, the court carves out this right to privacy. Okay. And so just when we're thinking about the right to privacy, it's been discussed in these two ways, and there's a very famous law review article that focuses on these specific aspects of privacy. But it guarantees in personal matters, for example, that individuals are free to conduct affairs free from governmental interference and regulation. And so there's really two strands to that. The first strand is avoiding disclosure of personal matters. So if you think of, your own privacy in not revealing educational records or medical records, right? There is some protection in avoiding, forcibly disclosing some personal matters. That's one aspect of privacy. But the one we're going to be focusing on is the second one, the second strand, the interest of the individual in independence and making certain kinds of decisions. So decisions about their body, decisions about their marital status, decisions about their children, right? And that as broadly sort of captured in this phrase, the right to be left alone. So there are certain times when you're entitled to privacy and to be left alone and not have that infringed on by the government, that the court said, and over many, many years, that warrants protection and that is a fundamental right. And again, because it's listed in all of those other amendments, it doesn't have to be enumerated for it to be understood as fundamental. Okay, so I'm going to stop there. I'm going to turn it over to Immacula to continue. We'll turn over to Dr. Trump.
Hello, everyone, and thank you for the opportunity to be with you this afternoon. My name is Dr. Immacula Cann, and I have my doctorate degree in nursing. And today I'm going to focus on three different areas, which is abortion, contraception, and also on healthcare providers and their concern regarding this particular subject matter. So in 1973, Roe versus Wade, there was a lawsuit which led to the Supreme Court ruling on abortion rights. The area that I'm going to really focus on, because Roe made several claims, but one claim that Roe made is right to abortion is absolute. A person is entitled to end pregnancy at any time for any reason in any way they choose. And what the Supreme Court decided is abortion right is not absolute. It must be balanced against the government's interest in protecting the health and prenatal life. The court did not agree that the Constitution guarantees absolute right to an abortion, meaning that the right to privacy does not prevent states from putting some regulations on abortion. So, there are risks, regarding forcing someone to a forced pregnancy. And those risks are physical health, mental health, financial burdens, and social stigma, which if you look at the history of Roe, and her real name actually was Norma McCorvey, and so she goes by the alias of Roe. Part of the reason that she wanted to have an abortion was because of financial burdens, and the court recognized that. But also the court also concluded that unborn have never been recognized in the law as persons in the whole sense. So within the different communities, whether if it's faith-based community, the healthcare system, there are different views regarding when life begins. So for example, the Jewish faith, they'll tell you that life begins at birth. For Catholics, life begins at conception. And me working within the healthcare industry, there are various views and research that actually has been done regarding when life begins. And what we have come to conclude is that life begins at implantation. So, there are significance to Roe versus Wade. And I'm going to read to you, I've read many articles, but this particular article is entitled Roe versus Wade, Case Summary, What You Need to Know. There are many people who think that Roe versus Wade is the case of legalized abortion. However, that is not exactly true, according to this particular article. What it did change was the way states can regulate abortion and characterize abortion as something that was covered under constitutional rights of privacy. So with that said, I have some interesting facts that I would like to share with you. Many believe that because of Roe, that we have an increased number of abortions that are performed in the United States. That is totally false. What the facts and the research and the literature have shown is that Roe did not have much impact on the number of abortions being performed each year in the United States. But what it did show is that the rates of deaths occurring as a result of abortion dropped drastically in the years that followed Roe. And what that tells me as a healthcare provider is that Roe, because of Roe saves lives. But Roe versus Wade has become a significant issue in American politics. On June 24th, 2022, the Supreme Court ended the constitutional right to an abortion in the Dobbs versus Jackson's Women's Health Organization. This decision explicitly overturned Roe versus Wade and handed this particular issue in the hands to the states to regulate. And the Dobbs decision, which was written by Justice Alito specifically indicated that the Constitution says nothing about abortion, and the Constitution does not implicitly protect the right. It is time to heed the Constitution and return the issue of abortion to the people's elected representatives. Folks, when I tell you that elections have consequences, elections have consequences. So please pay attention as to who are your representatives and are they really reflecting the views that you are electing them to represent. The conservative justices states that the 14th Amendment does not protect a woman's right to choose whether to continue her pregnancy. And for me, reading this, the scary part for me as a woman, as an African-American woman, is really Justice Thomas, who support ending all rights under the 14th Amendment, including birth control. Also, he indicated ending private sexual acts and interracial marriages. For me, that's pretty scary, because especially when it comes to the area of contraception, the court has already allowed some employers to decline offer of workers, contraception to workers. Court decided the government could not force contraceptive coverage requirement from the Affordable Care Act on employees' belief. So there's a lot of confusion regarding
I think we lost.
Yeah, I think we, let me see if she comes back on. If everyone could just bear with us a moment, please. I wonder if she lost her internet. Oh, there she is. Okay.
I am totally sorry. Can everybody see me?
Yes.
I am totally sorry with what just happened with my phone. So going back again, the court has already allowed some employers to decline offer of contraceptive to their employees. The court also decided that contraceptive coverage requirements from the Affordable Care Act cannot be forced on employers and their beliefs. So there's a lot of confusion around the issue of contraception and how it works. And there are many states already that decided to ban certain type of contraception. So therefore, women cannot have access, to something that a right that they had access to previously, which has women, within this circle, and also as men, we should be very, very concerned. So some facts that I really wanted to share with you and for you to think about is, how does this really impact, us as a society? Well, millions of people will be directly impacted where abortion is expected to be banned or criminalized. It is still unclear, how difficult it will be or impossible it will be for women to, let's say, go out of state to get an abortion. And we're very fortunate in the state of Connecticut, the work that we have done, to really support women and protect women. However, it still needs to be seen in terms of traveling, how does that affect women? And for me, a big thing that came in my mind was human rights. That are already embedded in the international treaties, which is ratified by the United States, of America. So what does that say? And how, what's the overall, impact, regarding that? And tell you a little bit of what research have really shown regarding the area of abortion, contraception, and healthcare providers and the concerns that we have. Banned or restricted abortions do not cease. They just go underground. So which means that with this particular issue going underground, there's going to be a lot of unsafe abortions, and we can go back into the era where a lot of women, could die. And that's a huge concern within the healthcare industry. So there's going to probably be a lot of unsafe procedures and unsafe practices. As a healthcare provider, I have to tell you firsthand that a lot of my colleagues are very fearful. What they've reported and what they're indicating is the fear of being reported to police and the fear of prosecution. And we also have to think of the effects of people who have historically has less access to healthcare services. And that could be due to discrimination and other systemic barriers. And these individuals, such as young people, Black people, people of color, people living in certain communities, people living in poverty, these decisions that has been taken by the courts and that could potentially other decisions taken by the courts could really impact a large segment of our population. The US already has one of the highest maternal mortality rate, and I'm talking in the spectrum of, wealthy countries. Imagine that we already have one of the highest mortality rates, and this could really greatly impact and raise mortality rates, especially among people of color and people living in poverty. So in one blow, the court ended protections for a key right that we've had for a long time. They've opened the door for government control of one of the most private decisions that someone can consider. There's a saying that says that in other countries that when America sneezes, the rest of the world catches a cold. Folks, make no mistake, what will unfold will be a human rights tragedy. And I implore each one of you who are here today to be engaged and to really know what's going on and to make sure that you are following through with what we need to do to help our society and protect the rights that we've had. So at this point, I'm going to turn it over to my dear friend Jean, and she'll do her segment. And I'm sorry if I had to go through very quickly. It's a lot of issues, a lot of information to cover in a very short span period of time. And I do apologize for the call coming through and me cutting for a minute there. Thank you.
All right, thank you, Immacula. I want to talk a little bit about how the Constitution works and why the Dobbs decision is going to have much broader consequences than I think people realize. The Constitution, yes, is a written document, which, yes, the Supreme Court and now everybody is supposed to follow. But the Constitution is not a code of laws. The Constitution was designed to be a limitation on the powers of the sovereign state, and all of the powers that the King of England had at the time of the American Revolution are what is limited in the Constitution, so that the rights that the Constitution protects were never intended by the founding fathers to be the only rights that we had. They assumed that whatever rights the average Englishman or Englishwoman had in 1776 was going to be preserved, and that what the Constitution does is limit the government's ability to affect those rights. Having said that, they did add the specific rights in the Bill of Rights, including free speech, the right to bear arms, and so forth, be free of searches and seizures. The court, in its wisdom over many years, however, has said that however fundamental a right has been, whether it existed at the time of Magna Carta, whether it existed at the time of the American Revolution, whether it was written into the Constitution in the first 10 amendments, all right, none of those rights, however fundamental, is absolute. So, for instance, free speech. Yes, free speech is one of the most basic rights we preserve. Free speech, freedom of religion, freedom of the press. But you cannot falsely shout fire in a crowded theater. You cannot libel or slander someone you dislike. You cannot join the Communist Party and advocate the total and complete violent overthrow of the United States government. These are all cases that have come before the Supreme Court, and the court has said, hey, wait a minute, we don't care what the Constitution says. Free speech is not an absolute right. No right is absolute. Having said that, privacy is even less absolute than most. It is pretty clear that the people who believe there is a right to privacy in the common law, that is the law that exists outside the Constitution, basically, we're looking at specific instances. And it was not clear until Griswold versus Connecticut that the right of privacy extended to marital relations or contraception or abortion. And in some cases, the right is stronger than in others. One of the rights that Justice Thomas looked at was interracial marriage. Strangely enough, the right to interracial marriage under the Constitution does not depend on the right to privacy. All right. All the justices throughout American history have agreed that the Constitution does not mention the word marriage. It just doesn't. But in the case of Loving versus Virginia, an interracial couple who could not get married under Virginia's laws at that time went to Washington, D.C., got married legally in Washington, and then moved back to Virginia, at which point prosecution ensued. The court invalidated the Virginia law on miscegenation, that is the marriage of interracial couples, not because the right to privacy was infringed, but because that law denied equal protection of the laws to whites and blacks. Whites were prosecuted under the law. Blacks were prosecuted under the law, but only for marrying each other. Whites could not marry Orientals, but blacks could, because in Virginia, the legislature felt that preserving the purity of the white race, whatever that is, was more important than preserving the purity of the black race, whatever that is. And that is a denial of equal protection. Whatever rights you give to whites, you must give to blacks and Orientals and American Indians. So interracial marriage does not rest on anybody's interpretation of whether there's privacy rights in the Constitution or not. Almost everything else of a private nature does. And that includes, as Immacula just said, the right to contraception, the right to abortion, the right to get married under certain circumstances, the right to educate your child. And if you think that that's not a live issue, consider that the state of New York is about to pull the certification from a large number of schools which they feel do not meet the minimum standards of the state of New York for what an educational service must provide, even though the parents of the children going to those schools favored those schools for other reasons, such as providing a correct religious background. The right to practice one's religion is a separate enumerated right. Question how much that right is impacted by the right to privacy if what you're doing in your religion is, let us say, handling snakes at home. Not a hypothetical case, by the way. So that the weakening of the right to privacy in the Dobbs decision, although Justice Alito said it only applies to abortion, he is wrong. Justice Thomas was right. The right to privacy is only as fundamental at this point as any group of Supreme Court justices thinks it ought to be. And when you look at what the court has tried in the past to let the states get away with, limiting what political parties you could join, limiting what kinds of speech you could make, limiting whether you could sell alcoholic beverages, limiting whether you could manufacture alcoholic beverages. There are whole bunches of things which the court has, in retrospect, we feel pretty much gotten dead wrong. All right. And one of the props that keeps the courts from just giving the states free rein has just been knocked out from under us. And that is basically, I cannot enumerate all of the things that have gone at risk because of the Dobbs decision. The only thing I can tell you is that the only one that seems to be fundamentally safe at this point is interracial marriage, because there is a line of cases which is outside the line of privacy cases, which protects that. But that is basically it. Everything else you do in the privacy of your home is now potentially subject to some degree or other of state control. We're not even talking federal control. We're talking what your state legislature can do to you in the way you live from now on. And that's not even assuming that the federal government doesn't provide some overarching support. The constitutional protections that you and I have been counting on in almost every facet of our lives is weaker than it was a year ago. All right. And if you think that these issues are not live, just wait until you see some of the cockamamie bills that have been introduced in the Connecticut state legislature and could be introduced again. So it's not just who you vote for president or for the US Congress that matters. What you vote for, who you vote for state office has now become more crucial than ever, because the overarching protection that we thought at least applied to some very personal decisions really isn't there.
Okay. Sujata, do you want to open this up to questions?
Yeah, thank you, Jean and Immacula. So I'm just going to moderate, take some questions from the group. And I think because this is a webinar, I guess the best way to do that is to either raise your hand, and Laurel, maybe, I don't know if you bring them into the panel to ask a question, or you can put it in the Q&A and then I can see any questions. Through the Q&A.
If people raise their hands, I have a button that they're allowed to talk.
Oh, great. So if somebody wants to raise their hand or put questions in the Q&A. While people, I have a question for you both. And then particularly about the healthcare system, but state systems in general. How do you think this is going to impact the relationships between states and certainly the cost on the healthcare systems of states that do provide protections, because more people are coming to the state for those protections, and we're seeing this now in the context of immigration. People, right? States are sending individuals to other states, and so, we just in this context, though, when it comes to particularly when we're talking about abortion and access to abortion, as people are going to states that are providing that, what is the impact on the relationship between the states and the impact on healthcare systems in different states?
I can say one thing about cost, and then Immacula is probably going to want to say something different. Right now, under federal law, Medicare does provide for contraceptive services, no matter what state you go to get them, whether they're legal or illegal in your home state. Federal law has been, by congressional action, does not provide Medicare or any other federal money for abortion services, whether you're in your home state or you travel elsewhere. So what's ending up happening is that people are spending their own money, all right? But the cost of getting the abortion is much higher if, in addition to the medical fees that the clinic charges you, you also have to pay for travel. And in some cases that have 24-hour waiting periods for an overnight stay at a hotel if you don't have a relative. Somebody once said the law in its majesty prohibits the rich man and the poor man alike from having to sleep under bridges. But the fact remains that this law is going to hit poor people way harder than it's going to hit women in the middle and upper classes.
Mm-hmm. Absolutely, I totally agree with what Jane just said, and actually, as you were asking the question, the first thing that I put is people living in poverty and the impact that would have on those individuals and people living in certain communities, and and also let's also face it, we already see the issues based on the literature of people of color and the type of services that they receive, even when they have money, even when they have insurance, and the inequality, of treatment. So within the healthcare industry, I can only see this really being a much more significant issue regarding that. But excellent question. Thank you so much.
And we have two questions in the chat. The first is, as for a solution, do we need to expand the Supreme Court?
That's a main question.
Speaking as somebody who was born after the great court packing debacle of the Roosevelt administration, my gut feeling is, yes, you could expand the Supreme Court, but what's to prevent the next conservative president from packing it with even more large numbers of conservative justices? Numbers aren't the answer. All right. The Supreme Court responds to public opinion, but very slowly and usually 2 or 3 generations out of step. All right. The worst examples of this were the Dred Scott decision, which basically was so far out of step with what the North wanted that it caused the Civil War. All right. And quite frankly, the decision which is letting private money in large amounts flow back into the electoral system, which most Americans do not want. And now basically the Dobbs case, which goes against the wishes of about 75% of the electorate. All right. And will go against the wishes of a lot more of us as other rights get cut away. So packing the court with large numbers, yeah, it's not a solution.
And let me just add, there are other solutions though that have been suggested, including term limits. And one of the justices, and I forgot which one now, suggested an 18-year, staggered term, and with some kind of term limit. Now the question is whether that's constitutionally permissible, and depending on how that clause is interpreted, not clear. But can there be a way to reframe the role of justices to serve for a lifetime in a federal court, for example, and a limited amount of time in the Supreme Court, still have lifetime appointments, but doesn't have to be a lifetime appointment, and then limit that role?
Yeah, but that leaves you open with the same problem with a conservative president suddenly having way more openings.
Mm-hmm.
Yeah, well, you staggered the terms. And so 18-year staggered term. So that would open it up for, right,
you would hope
more
that
regular
there
appointments.
would be Democratic and Republican presidents roughly alternating. I don't think there are any guarantees. All right. Changing the term on the Supreme Court also means that you end up with justices with less of an institutional memory. Some of the decisions in some of the later abortion cases really did not pay attention to some of what the earlier cases said in some ways. So unless you've got judges who've been through the arguments and have heard both sides for a long time, you run the risk of decisions being even more short-sighted than they are now.
So Jean, what's your solution then for reform?
I don't think the court needs reform, but take a look at the current Supreme Court. The 3 most conservative justices on the court, Trump's appointees, were appointed by a president who never won the popular vote. Hillary Clinton got more votes than Donald Trump in 2016. The solution to getting the Supreme Court that looks more like what the population of this country wants is to reform or eliminate the Electoral College.
Political reform.
It's a political issue.
Yeah. And also to Jean's point, in terms of how the court's decisions are lagging, and it is really based on public opinion. If you look at the history in the 1960s of the women's movement, and how strong women came out and was, demanding their rights and so on and so forth. I think the women's movement in the 1960s really helped when Roe in 1973 was presented, at the courts, and I think that really put pressure, in terms of the court, deciding based on public opinion, so I think that's an excellent point, that's made regarding the court decisions and the public opinions and what was going on, but also you can see how they lagged. It took, 13 years, after when the women's movement in the 1960s for them to really say, in terms of the rights, of women and our bodies.
And those social movements though, and that the relationship there, as you mentioned, is also really important.
Yes.
And let me there's two more questions in the chat. The second one is related, I think, to this conversation. So let me just ask that one first. Can the number of Supreme Court appointees per president be limited?
Sure, but what happens if you've got vacancies on the court? You end up with 4-4 or 3-3 decisions. You basically, the problem isn't the court. The problem is who gets to put the justices on the court.
And the process for
doing it, which is a hideous mess. Advise and consent in the Senate has left a great deal to be desired.
And then we have another question. As of right now, how many states have banned abortions in the United States?
That's a very good question. And I want to say in the area of 28 states that's either restricted or banned abortions. Yes. Am I right, Jean?
Yeah, I believe 13 with outright bans and another 13, 14, or 15 with very severe limitations. But that number could change at any moment. Yeah. That's the trouble with the Dobbs decision. All this changes, all that happens is you get one change in a state legislature and it's up for grabs. Unless the state has a constitutional protection for right to privacy in the state Supreme Court that's willing to say that that right extends to abortion, which is something the US Supreme Court does not.
Right, because states can grant constitutional protections beyond what's granted in the federal Constitution.
Yes, they can.
And then another question here, Jean, I think for you, how can a code of ethics be implemented for the Supreme Court?
That is virtually impossible. The Supreme Court has for many years operated under a self-imposed code of ethics, and more importantly, a self-imposed set of rules about how fast they should make changes in the law. There is a doctrine called stare decisis, which means you follow precedent, which is not required by the Constitution or by the common law, although the common law does give great weight to prior precedent. That's one of the reasons it's laws and not random actions. And the court has, up until the Dobbs case, said basically that because of the way the court internally polices itself, they will not overrule a prior case unless the understanding of the facts has changed, the facts underneath have changed, or some other thing happens that's sufficiently momentous. In the Casey decision on abortion, the court got rid of this they had a very rigid first, second, third trimester breakdown in Doe and Roe. And they changed that because the ability of the medical profession to keep fetuses alive at an earlier stage meant that viability was now being pushed earlier and earlier. All right. And one thing Roe had said is that when the fetus becomes independently viable, you can't abort except to save the life of the mother, essentially. So viability was getting pushed back into the second trimester. So the court sort of abandoned that rigid trimester structure. And they didn't overrule Roe, but they modified it in Casey. And they can do that. It probably won't interest most of your viewers to know this, but there was an earthquake in the legal profession about 100 some years ago when the court switched gears for many years, the court had said that they would follow the procedures of the states that the cases arised out of, but they would have independent federal law. And lo and behold, they decided that just wasn't workable, and they switched. So now they try to follow, there's a code of federal procedure. But the substantive law, they try to follow whatever the state says in a state case. And the way they deal with that in the abortion cases and in the civil rights cases and in the free speech cases is that they will only overturn a state law if there is no rational basis for that law. Or in the case of racially discriminatory laws, they will apply a slightly separate standard. But basically, they will let a state substantive law stand now unless there's no rational basis for it. That is a 180-degree turnaround from what it was back when the court first met in the 1780s or whenever it first met.
So should this case have been decided under, as Ruth Bader Ginsburg, suggested, under a different constitutional standard, Jean, which would have given it better protection?
Considering that I don't believe that there's an unfettered right to privacy in the common law, I'm inclined to agree with Judge Ginsburg. Yes, Justice Ginsburg. There were other grounds. I would have treated it as an equal protection argument from the outset. If Blacks and whites deserve equal protection, despite hundreds of years of racial stupidity in this country and elsewhere, all right, including Great Britain, where our laws come from. All right, women and men should be treated as equally as possible. Men admittedly cannot carry fetuses, but women should have the same right to determine what happens with their own bodies that men do.
Immacula, what are you sort of hearing in the field, in the healthcare industry, about the reaction to this legal precedent? I'm guessing that people are talking about this much more, and especially in states, I would say, where there are perhaps state constitutional protections, and more people are now coming to the states to access, healthcare service. Are people worried about the overburden there, or what's happening in the field?
I'm in much demand today. I am so sorry. Being at work and very much demand. We have a new telephone system, and I'm trying to, oh boy. So in Connecticut, my colleagues, and based on what I've been reading, there's a level of comfort and a level of feeling safe with the healthcare providers and their licensure, based on the work that we did at the legislative session, this past legislation. So in Connecticut, we have that. However, the concern that within the healthcare industry and many folks that I have communicated with is, while there's protection for them, with their licensure, what about the patients that they're treating? And going back to their home states, what does that, will they be criminalized? And although here, they feel, based on the laws that we've implemented and we've put in place, that they have a level of protection, but for how long? And who will be, in election season? What's the dynamics going to be, at the state capitol, and what's going to be changed? And when those changes occur, could, let's say, if they were to perform abortions or give contraceptions and et cetera, could then other states go back and now prosecute them for what they've done? So it's really a very complex issue. And it's really making a lot of people feel very uncomfortable. And, you know, in terms of what they could do and what they should do. But,
Yeah.
you know, looking at what, you know, what
And where they can go to visit family
Yes,
or on vacation. Because
absolutely.
if you've got family in a state that goes after people who provide abortion or contraception, and somebody finds out you're there.
Yeah, absolutely. Yeah, so it's a very complex issue, and I don't know if there's really a answer, you know, to that, because, you know, doing my research, one of the things, you know, that's interesting, that is still very unclear, and that's probably going to be decided, and hopefully it's addressed, you know, it's the right, you know, to travel. You know, are we going to really restrict individuals' right to travel? And if we do, you know, then you're essentially putting women in prison, you know, in terms of what they can and can't do. Going to other states for them to get the healthcare services that they need.
Yeah, so many questions implicated. And I like that this panel, we're looking at both the legal implications and the medical implications, right? The healthcare implications, because there's so many there. Wonderful. So we're coming up at the end of the hour. I don't see any other questions. Are there, just maybe I'll take a minute to see if there are any other questions in the queue, if you want to put your question in the Q&A, or if you just want to raise your hand. But I just wanted to, if not, I just want to thank our two panelists for a really terrific discussion. I hope people are sort of thinking about, you know, the implication, both the legal implications, the medical implications of this Supreme Court decision and other Supreme Court decisions, and, you know, paying attention and getting involved. I think that's really the most important thing as well. Oh, and I think there might be one more question. Oh, just thank you. Thank you for a great webinar. Yep. Great. Thank you. Thank you all for attending. Yeah, have a great afternoon. Laura, I'll turn it back to you.
Okay, well, thank everybody so much. Stay tuned. We're going to have a couple more of these, and hope you'll be able to attend those as well. Thank you all very much, and thank you so much, panelists, for all your research and your presentations.
Thank you, everyone.
Thank you.
Have a good evening and a great weekend.
Thank you. Great weekend, everyone. Bye.
All right.